Ashley Benefield, a former model and ballerina, finding herself at the center of a high-profile trial after being accused of shooting and killing her husband, Douglas Benefield. Claiming self-defense, Ashley's case sheds light on the complexities of domestic violence and the legal challenges that arise when trying to prove justifiable force. All this weekend on the Hidden Killers podcast, we're examining the case of Ashley Benefield, examining the events leading up to that fateful day in their Lakewood Ranch, Florida home, and the allegations of abuse Ashley made against Douglas. We're taking you to the courtroom for raw audio from the Stand Your Ground hearing of Ashley Benefield all weekend here on the Hidden Killers podcast.
All right, the witness has stepped out. On that particular point, I got some pretty decent notes, and I was listening. My notes are not that he said that, just that he observed that Mr. Benefield was starstruck. I mean, nobody clarified, how do you know that? Did he say it? Was it your observations? So I don't think that's necessarily a statement. What other statement in particular? There was one I overruled. I didn't see it as being offered the truth of the matter asserted, so I didn't see it as hearsay.
Sure.
I know there was one of those.
My objection was on the basis of hearsay. The court allowed it, and I think if you will, the danger of 806 and why it's can be a two-edged sword is that it does not restrict the subsequent admission to anything relevant to the hearsay statement that is allowed. It rather sets up the credibility issue. And once a hearsay statement is allowed into evidence, then any other statement that the declarant made that is not available is admissible if the credibility of the declarant is being attacked. So, for example, on cross-examination, I question the witness about these violent acts by the deceased. Some he acknowledges were told to him, some he denies were told to him. If I have an admission, even though it's in a hearsay statement, if I have an admission by the declarant, it is at that point admissible according to 806 in evidence. It doesn't make a difference that the hearsay statement, Judge White, is related to the hearsay that the court admits.
So you're saying if one hearsay statement is let in, whether, and let me also say, somebody might object to hearsay. Overruled doesn't tell you if I overruled because I don't see it as hearsay. It was a statement, but it wasn't offered for the truth. Could be that I went through the catalog of exceptions and found as one of those. So I wouldn't read too much into overruling a hearsay objection.
Sure, and I understand.
And 806, familiar with it, and it's when a hearsay statement is put before the trier of fact or into evidence, that the hearsay declarant's credibility can be attacked or supported as allowed by the rules. I don't think it kicks open the door to any possible hearsay statement the declarant ever made on any topic at all.
Respectfully, if it goes to the declarant's credibility, I would say it does. And I think that the statute and the case law will support that. Because, again, it's not tied to the relevant.
I didn't say credibility. I said any hearsay statement. That's what I'm hearing, is that we can bring in any hearsay statement.
To the extent it supports an attack on the credibility. Yes, sir. Yes, sir.
That I don't disagree with. A hearsay declarant's credibility can always be attacked or supported pursuant to the rules.
Right. So it's our position then that any hearsay statement that supports our attack on the credibility of the declarant is admissible. And specifically, in our motion, we have several of them, and we appended them as exhibits. So I think that they are now admissible by virtue of 806.
I'm still not sure exactly which ones you're talking about, but state.
And Judge, confused because at the base of it, the defense elicited the hearsay, and then he's trying to bring in hearsay to impeach from the hearsay statement that he brought in. I don't understand this, but 806 says that once a hearsay statement comes in, that other evidence can come in which would have been used had the person testified. So I think we're still bound by the rules of what can come in. Just because someone may be impeached on one statement doesn't mean every hearsay statement they've ever said comes in. That's different than credibility. So to be honest, Judge, I'm a little confused.
I am too. And let me make sure I understand. You had mentioned something, and I didn't want to get into it too much because the witness was here. And I think this was also mentioned, Mr. Taylor, I think this was also mentioned in the defendant's motion in limine, that there were some discussions about certain evidence not being relevant, and you were going to just talk about very surface level things, but it seems like we got, instead of a scalpel, sounds like we got a shovel out and we're going to start digging some holes.
Point well taken, Your Honor. Actually, the discussion was limited to the allegations of abuse. That is to say, both Suzanne and I felt, rather than going down the rabbit hole of litigating whether or not the allegations of child abuse against the daughter were true or not, we would not go there.
So the agreement was limited only to allegations of child abuse?
Yes, sir. And truthfully, we never executed an agreement, but that was a professional discussion that we had, and I'm confident that Suzanne will acknowledge that.
All right. State?
We did have that conversation about the child abuse allegations. I do not remember specifically excluding anything before the child abuse allegations. And if there was a miscommunication, I apologize, but I had assumed that that would be a part of the let's not go down rabbit holes, because the issues that have just come up have already been litigated and have already been ruled on by another judge. So I was under the impression we were not going to get into those that happened in South Carolina.
Yeah, again, I don't know. I wasn't part of the agreement. I can say this. So there's two general ways a hearing like this can go. And I'm talking very, very broad strokes. One is how I thought we had agreed to do this was that pretty much we're going to let stuff in and object as we go, and then I'll decide the relevance or if things are relevant or not relevant. And I understand that that means a lot of things come in that might not normally come in, and those things may be relevant or not relevant. So I'm going to listen and hear a lot more testimony and see a lot more evidence than I might not normally, but it's to allow you guys to just put on your cases. The other way is we take a step back from that, and I will grant or overrule objections as we go. I personally think that'll take a lot longer, but it'll also limit how much evidence is put into the record, and we can do it that way too. My rulings so far, I would think both of you would agree, have been very generous towards admissibility, because that's what I thought we agreed on. So, but if that approach is then going to be, well, Katie barred the doors, here it all comes, and we're going to spend tons of time. We're going to stop here. We're going to get off the bus, and we're going to spend a day looking around over here. Then we're going to get back on the bus. We're going to go a little way down. We're going to get off the bus. We're going to look all around here. I'm not doing this so I can have hours upon hours of testimony about somebody shooting a gun at a house, punching a dog, putting a tracker on a car, peering into a window, punching a hole in drywall, and alleged domestic violence in a prior marriage. I'm not going to hear hours and hours of testimony. So I need to know. I'll start with the state, start with the defense. Are we going to do the plan that we originally laid out, which is, hey, put your stuff in, right? And then I'll figure it out as we go. Or am I going to throttle this down and I'm going to start listening to more objections? Not that I haven't been listening, but take more of the approach of, no, we're not letting irrelevant stuff in. We're not going to have hearsay. State.
Judge, I would not want to continue with everything that we're doing now. I don't necessarily think that we need to completely curtail it, but I do think that some of it needs to be throttled down. If there's an objection, I think that you should rule on it appropriately.
All right, so that's a mix. All right.
So I take that to be the former position, which I agree with. I am quite comfortable there's no jury here. I am quite comfortable with the court parsing the evidence when the time comes for the court to rule and author an appropriate order. And that was why I said I'll address it later. I wanted to make my point and move on. And I'm satisfied if we continue to go with that way. I
All right.
It's going to be consistent with time savings and efficiency.
But it hasn't so far because we're spending a lot of time having this discussion now.
Yes.
So it hasn't been the time savings that I had planned. So I guess my question is, I don't know what statements you want to get in. I don't know what evidence that you want to get in that you're arguing comes in under 806, which, if I'm understanding your arguments, I don't think I read as expansively as you do. I think a hearsay declarant's credibility can be attacked or supported, if attacked, as if the hearsay declarant had testified. But that's still within the bounds of the Florida Evidence Code. I don't think it kicks open the door for every hearsay statement that has ever been made. But the second DCA will tell me if I'm right or wrong. So let's call the witness back and we'll see if we're on the same page and we can go from there.
I believe we were at the end of defense cross, or I was at the end of my redirect. Were you going to, I don't know if we need the witness back.
I will tell you this.
Agreed.
There was recross. The question was, how did you hear about Sully? And did you hear about it from Mr. Benefield or Miss Benefield? And the answer was, I heard from them both.
So it
Now,
was on defense cross.
I'll just say, I don't know where this is going. I don't know how much you plan to get into defense. I've read, this is not the entire pile of what you sent me, but this plus everything else you sent, I've read it. I understand, well, the portions of the depositions. I didn't get entire depositions. I've read it. I mean, I understand that what he said about that, the incident with the dog. I understand what she's saying about the dog. I just don't know how far we're going to go down that hole.
I hear you, Judge. We're finished with Mr. Benefield.
Okay. I don't want to curtail you. If you have any questions, I want you to ask your questions.
I understand. I appreciate it. We're on the same page.
All right. So Mr. Benefield is done.
Yes.
Okay.
And he can be released.
That's my next question. After each witness, I will ask, can the witness be released from their subpoena? So, state?
Yes.
Yes, sir.
All right. So we're going to call the next witness, and can you let Mr. Benefield know that he is released from his subpoena? And who's your next witness?
I'm sorry.
Your next witness.
Oh, Stephanie Murphy.
Would stand face the court with right hand respond.
Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth?
I do.
Okay, where did I put my notes?
Stay about 12 inches from the microphone.
No, I'll find it. Hello, ma'am. My name is Judge White. I'm going to be presiding over this hearing. As the deputy said, if you get about 12 to 15 inches from that microphone, it adjusts up, down, left, and right to wherever you need it comfortable. And if you just speak in a loud, clear voice, it should pick up everything.
Thank you.
Thank you.
Good morning.
Good morning.
Please state your name.
Stephanie Murphy.
And what do you do for a living?
I'm an attorney.
What type of law do you practice?
I practice family law.
And do you work for someone or are you self-employed?
I'm self-employed. I have a firm in Sarasota.
How long have you had that firm?
I've had the firm for approximately 15 and a half years.
And were you hired at some point by Doug Benefield?
Yes.
Do you recall when you were hired by him?
I first met with Doug Benefield on March 13th, 2018. He retained me on a partial retainer the following day, on the 14th of March.
Okay. And what was the purpose of him hiring you on that day?
On that day, I was retained for a limited purpose of communicating with Ms. Benefield with regard to the upcoming birth of their child.
Okay. So the defendant was pregnant at the time.
Correct.
And do you recall when her due date was?
I believe the original due date was April 8th of 2018.
Okay. And you said your initial responsibility was to communicate with her.
Yes.
So did you attempt to communicate with her?
I did. I sent her a letter via email on March 15th, 2018 at approximately 9:59 in the morning.
And without getting into all the specifics in the letter, basically what was the gist of it?
The general gist of the letter was that with knowledge of the upcoming birth of their child, Doug wanted to express his interest and desire to be part of the birth process, to be present if possible, but also wanted to communicate that if Ms. Benefield felt uncomfortable about that, he wanted to respect her space.
Your Honor, for the record, object to hearsay and relevance.
Yeah. Is this being offered for the truth?
No, it's just basically being offered to show that this is how the communication started and that the letter was sent to Ms. Benefield.
Okay. Did you want to respond to that? I'll just say I was not taking this as for the actual truth of this.
Yeah.
If it's intended to be for the truth of these matters, then that's a different issue.
No.
Well, I think it's obviously intended to quote unquote educate Your Honor based upon the hearsay that this witness has to offer. So continuing relevancy.
Yes, sir.
Hearsay object.
Go ahead, ma'am.
Okay, thank you. Did you ever, let me back up. I don't know if you said this, but in what form did you send her this communication?
It was a letter that was saved as a PDF that was emailed.
Okay. Did you ever receive a response from her?
She never responded to me directly, no.
To your knowledge, did she ever respond to Doug?
No, not at that time.
At some time shortly after that, so the baby was born in, or when was the baby born?
Well, baby was actually born quite early. The next day after receiving my letter, she checked herself into Tampa General Hospital and then started a induction of labor process. And so the baby ended up being born about 3 weeks early, I think March 19th of 2018. I may be off a day or two.
So middle of March. The baby was
Correct.
born. To your knowledge, was Doug there?
No, he was not there. He had no idea the baby was born.
Did the defendant file for an injunction shortly after?
Yes.
And what date was that?
My memory is that it may have been, excuse me, May 1st of 2018. It could have been in April. There was a bit of a lag between when she filed it and when we had knowledge of it because the injunction was actually denied but a hearing was scheduled, so Mr. Benefield was not served.
Okay, so just to be clear, you said the injunction was denied. Are you saying the temporary was denied?
Correct.
Okay, so an injunction was filed, a temporary was denied, but it was set for a hearing? Is that what you
Yes,
said?
that is correct.
All right. Do you recall when the first hearing was set, approximately?
It was shortly after we found out about the injunction. So I think we found out, meaning I, found out on May 6th of 2018 that the injunction had been filed, which is how we knew that the baby had been born and what the baby's name was. And then the hearing was originally set for shortly after that, I think just a couple of days.
Okay.
Ended up getting continued anyway at Ms. Benefield's request.
Okay. So it was set pretty close in time, but it ended up getting continued.
Correct.
Before the hearing was actually held, did you end up filing something on Doug's behalf?
Yes, quite a few things.
And generally, what did you file?
Generally, it was a petition for a parenting plan unconnected with divorce and a motion for psychological evaluation. Those were the initial pleadings that we filed.
Okay. Ultimately, were these issues all to be addressed at the same hearing?
Ultimately, yes.
Okay.
Well, let me clarify. No, because then when the hearing ultimately took place, it wasn't the original petition for parenting plan unconnected with divorce. It was actually an emergency motion for a temporary time sharing and parental responsibility. But both cases traveled together, and so pleadings or motions in both cases were heard at the same time.
Okay. So while the motions themselves may have changed, the two case numbers were heard at the same time?
Correct.
Okay. So at the time, Doug had an emergency motion for time sharing?
Yes.
And what, just briefly, what is that?
When there's a child, there's no such thing in Florida as custody anymore. Parents have time sharing with children. Ms. Benefield was withholding time sharing of their daughter from Doug. And so the appropriate way to seek time sharing was through the court versus taking matters into your own hands.
Okay.
He was also seeking parental responsibility, which is the decision making.
Okay. And when was that hearing held?
It was held on 2 different days. It was July 30th and September 17th of 2018.
So you did have part of the hearing on July 30th, 2018?
Yes,
And did not finish, I'm assuming?
we did not finish.
Okay. What judge was it?
It was Chief Judge Diana Moreland.
And before that first hearing, was there a motion to recuse the judge?
It was a motion to disqualify Judge Moreland.
And was it granted?
No. They appealed that decision and filed a motion to stay pending appeal. That was also denied.
Okay. So the hearing continued.
Correct.
Then it continued again for the rest of the hearing in September.
Yes.
Okay. So I don't want to get into the specific facts of the allegations in the injunction, but if you could just tell us generally what were the topics, the injunction.
It was a wide range of topics. The most alarming was she had allegations that she was poisoned by heavy metals and that the baby had also been poisoned in utero. She alleged violence of a dog.
Oh, I'm sorry. I thought we were going to talk more about the poisoning. So
Okay.
Violence with a dog.
Correct.
Poisoning.
Right. Threats, and that he had discharged a gun in the home.
Okay. After this hearing, did Judge Moreland make a ruling?
She made a ruling at the conclusion of the second day in September. Yes.
And what was that ruling?
Her ruling was
I'm going to sustain as to her ruling on these issues. I mean, I'll hear,
And
go ahead.
I'm sorry.
Put whatever you want on the record.
This we may need to have argument about, Judge. It is my argument, it's the state's argument, that the content and the manner in which, I have the order recorded, the judge made this ruling set the stage for the defendant's behavior later on down the road, because she knew that this judge felt the way she did, and she had a hearing in front of this judge 3 days after she murdered the defendant. So I think its effect on the listener, and I have some case law we can argue if you'd like, but this manner in which this order was given is highly relevant to the defendant's, the effect on her.
All right. So you're not introducing Judge Moreland's ultimate order to influence one way or the other to prove that it was correct.
Correct.
It's the effect on the defendant.
Correct.
All right.
Whether it be right or wrong, the ruling, I'm introducing it for the effect on the defendant.
Yes, sir.
I don't have a problem with that. The problem that I have, which I think the court is well aware of, is the characterization of the presentation.
Right, absolutely. If it was for the purpose of, hey, judge, this other judge ruled this way, therefore, that's what we want.
Correct.
But if it's to show the effect, and yes, that one of the cases you had submitted illustrated that very point. So I get that.
Well,
all right.
I want to make sure we're talking about the same thing. I don't have a problem with the state's theory that this decision prompted the subsequent action. What I strenuously object to is the statement by Judge Moreland, the characterization of the quality of the hearing. That, I think, should not be stated in this proceeding. I think it's irrelevant. The decision itself, I don't have a problem with. I can tell the court, well, let me just leave it right there, right now.
All right. I don't know what the statement is. I'm going to have to hear it eventually, and then I just won't consider it, but it was.
Approach the bench.
Yes. Let's do this. We got some new headphones, and as it invariably happens when you introduce new hardware into a system, we've got to get it fixed. So why don't we do this? It's kind of a good time for a mid-morning break. So why don't we take about 10-minute break? It's 10 after. We'll see everybody back at 10:20. We'll get this issue solved. Ms. Murphy.
Yes.
The rule of sequestration has been invoked. We're going to take a 10-minute break, so you will be, I'm sure, milling about the hallway. I know you're familiar with the rule of sequestration and what that means regarding your testimony and who you can talk to. So please make sure you follow that closely.
Absolutely.
We'll see you back in about 10 minutes.
Thanks so much.
There is more to come in the Ashley Benefield Stand Your Ground hearing. We're bringing it to you all weekend long here on the Hidden Killers podcast. Press subscribe so you don't miss a minute of courtroom coverage. I'm Tony Bruschi. Stay with us.